Good evening and welcome to HCA 551. My name is Craig Heckman. If your goal is not to be in HCA 551 in another class or watching something else on YouTube like people slipping and falling on the ice, then find another channel. This is the introductory lecture. I want to talk about a couple of things. Number one, everything you need to know about how the course will be graded, what the assignments look like, where the assignments, when the assignments are due, all of that is in the written syllabus. So I'm not going to repeat what's in the written syllabus. Read it, you'll understand. You've got an assignment that is due on Sunday of each week, unless you receive instructions to the contrary. If there are any questions or if somehow the syllabus isn't clear, send me a note, call me, whatever is required. The syllabus does contain the best ways to get a hold of me, which are certainly by email, by text, by phone. All those avenues are detailed in the syllabus. So, this is an online class, and it's kind of an adventure. I've taught for a long time. Some of you I've had in class in the past. I've taught 441 at Western since 2000, but this is the first time that the class has, from the get-go, been designed to be an online class. And for that reason, it's an experiment. The university is experimenting, I'm experimenting, and congratulations, you are the guinea pigs. So we'll see how it goes. I think it's a chance to do things differently. At my end, it's a lot of work, but I think we're going to do what we can to make online successful. So bear with me. There may be some things along the way that we find out just don't work as well as I thought they were going to work, so we may have to change the structure of the class as we go along, but I've put a lot of thought into it and believe that the way we've got it set up should work for everybody. All right. I'm trying to think what else I have to do. In the way of preliminaries, again, all of it is laid out in detail in the syllabus, so go to the syllabus. I realize the syllabus is now a whopping 9 pages or something, but half of that is the university is required that we now put in a crosswalk that shows how we're going to address the goals, the core issues for the department in the course of the semester. Don't be daunted by the fact that the syllabus is 9 pages. There's about 3 or 4 of it that are relevant to this class and this class alone, so kind of focus on those as you're looking at it, but please do read the syllabus. All right, what we're going to do, and this is one of those things that I'm not sure exactly how well it's going to work, but I'm going to be giving lectures. The lectures are going to come to you as videos that are recorded. They won't be live Zoom sessions, so you'll get the class to look at whenever it is that you want to look at it. But I would encourage you, if you're going to do well on the test, if you're going to do well on the quizzes, if you're going to do well in this class, to watch the videos. It's kind of like going to class. You know, you're going to do better if you go to class than if you don't. Then in addition to that, the class, for the first time ever, I'm going to be trying to basically use PowerPoint. I'll use Google's version of it, Google Slides. So the goal is to try to have the lecture and the slides work together. This is a lot harder than it sounds, or at least it's a lot harder for me than it sounds, than I thought it would be. And to make that work, what I would suggest is that you either put the lecture on one device and put the slides on another device, or put them both on one device and use a split screen, because the slides are intended to go along with the lecture. Doing a screen inside a screen seemed to be something I just couldn't quite manage. So at any rate, if you haven't got it yet, find the slides that go with this particular lecture, which I think is called Introduction to the Law, and we'll go from there. Or actually, I take that back. For Introduction to the Law, we don't have the slides. I'm sorry, there are no slides for Introduction to the Law. There's just a straight lecture and no slides. The slides really start with the chapter on torts. So for Introduction to the Law, what I think is important for you to know and understand is that for some people, the law is when they hear the word or think the word law, they think it's something that either has nothing to do with them, or they think it only has to do with them when the police car pulls them over and they get a speeding ticket, or worse yet, when I say the law, they think of a somewhat fuzzy recollection of riding in the back of a police cruiser on a Saturday night. Maybe they think of the fine print in a contract that's peppered with words like whereas and party of the first part. For me, when I think of the law, the image that I conjure up is the rows and rows and rows of decisions that have been made by the courts. They're bound in volumes, identical volume after identical volume after identical volume. If you go to Western up on the 9th floor at the library is that tall building. If you go to the library, you'll find these books. There are literally thousands of volumes of them, and each volume has about 1,000 pages, usually 1,100 to 1,200 pages to a volume. And so there are millions, literally millions of pages of written decisions by judges that have been writing decisions for as long as we've had a legal system, really, in the United States. And the legal system that we have in the United States is one that we borrowed very heavily from England. And we did that because the intellectuals that were coming to the United States or coming to the colonies at that point were, for the most part, the intellectual class was a class composed of people that had trained in England or had learned in England, or as we got farther along, learned at schools in the United States that were based on English schools, and many of them had trained as lawyers in England. And our founding fathers, many of them went to school in the United States, in what became the United States, many of them at William and Mary, for instance, and they learned the English system, and it worked pretty well. It wasn't flawless, and we've modified it, and so that we now have an American system. But that American system is one that is based on the English system at its heart. In England, they had something called common law, and we still use the idea of common law in the United States. And common law comes from the experience of human beings rather than from the statutes written by the legislature. And when I say it comes from the experience of human beings, what happens is, as unique fact patterns are presented to the courts, the judges reach the decisions that they reach about what should be done. And that body piled on top of it, piled on top of it, piled on top of it, creates the foundation for the American legal system that is called the common law. Certainly we have legislatures. They had legislatures in England as well, but the common law is that judicial-based decision-making that gives us things like the idea of what negligence is. The definition of what negligence is, which we're going to get to in the next lecture, but the definition of what negligence is not something that comes from statute. It's something that comes instead from the common experience of what's right to make a society work better. The ideas that we have about what it takes for a contract to exist are concepts that we get from the common law. These are ideas that came from judges thinking about, John and Bob had an agreement. What was that agreement? Is that an agreement that should be enforceable or not enforceable? What are the rules we're going to make? So that's the common law. When we talk about the American legal system, we have to understand that there's lots of ways to slice it and dice it, but one of them is to recognize that we have a federal system. And when I say we have a federal system, what that means is that there are laws passed by the federal government, but there are also laws passed by the individual states. And the laws of the individual states are very important, and they allow Kentucky to do things differently than Ohio, and Ohio to do things differently than Pennsylvania. They also allow both of those to do things differently than the federal government may want to do things. There are, in the Constitution, certain areas where the states and the federal government have what's called concurrent jurisdiction, meaning that they both have authority to regulate something. So they both have the authority, for instance, to regulate some aspects of of medicine, specifically, for instance, when we get into things like radiology, where the federal government has long taken an interest in radiology and what the rules should be about what doses are appropriate or inappropriate to give somebody in the way of radiation in order to get a good image. But those are also issues that can be taken on by the state. So there's concurrent jurisdiction where either the state or the federal government can create the rules that apply in those areas. There are other areas where it's reserved for the states and the states alone, and the federal government, it's none of their business. And yet there are third areas that are the business only of the federal government and not of the states' governments. For instance, regulating interstate commerce, the commerce between individual states. I will simply say, and it's not really the purpose of this class to go into this in any great detail, but I will say that the federal system always has with it the notion that if there is concurrent jurisdiction, and that is jurisdiction by available or rulemaking possible by both the state and by the federal government, that rulemaking by the federal government is always going to be supreme. It takes priority over the state government. So keep that in mind, because along the way we're going to see, for instance, when we get to the issue of privileges, of when doctors are allowed to talk about their patients and when they're not, those are governed by state law. And for that reason, we have different rules in Ohio than we have in Kentucky, as an example. I want to talk about the two hemispheres of the law, and this is something that I think you have to understand kind of at the get-go. This is the basis by which our legal system is held together. We have civil law and we have criminal law. Criminal law has its own set of rules and its own set of procedures that are different than the rules and the procedures that we have for civil law. So, as an example, in the criminal law, for someone to be convicted of a crime, it's required that we have a unanimous jury verdict. If there is a jury, the jury has to unanimously reach the decision that someone is guilty, or else they won't be found guilty. That's just how that plays out. Whereas in the civil law, it is not required that we have a unanimous jury verdict. So these are just two different hemispheres with two different sets of rules. Let me suggest to you that if you think of these two different hemispheres, they're part of the same world, but they just are like, it's winter in Australia when it's summer in the United States. Part of the same world, but they're operating under different sets of rules. That's how we kind of have it. When we talk about criminal law, what we're really talking about are things that are offensive to society at large. As an example, it's offensive to society at large that someone commit murder. It's not just offensive to the person who was murdered. It's not just offensive to their family. It's offensive to society at large that someone be murdered. So we make that a crime. And as a result, in criminal cases, what we have is it is the state, for instance, the state of Kentucky or the Commonwealth of Kentucky, versus the person who is the criminal defendant. It's not the person who died against the criminal defendant, because it's an offense against society at large, and we're concerned about that, and we care about that. We find it offensive that people rob people. We find it offensive that people commit various types of healthcare fraud. We find it offensive that people spit on the sidewalk. So these are all crimes, and they fit into the criminal hemisphere. In the civil hemisphere, what we're really talking about are the relationships of individuals. And when I say individuals, this can include corporations. It can even include the government. But it's a different dynamic that's taking place. In the world of civil law, we have things like the law regarding torts and contracts and corporations, bankruptcy, divorce, probate. These are all matters handled by the civil law and are handled by a different set of rules than we have in the criminal law. So keep that in mind. The two different hemispheres. Know which hemisphere you're in. Most of this semester we'll be talking about things that are taking place in the civil hemisphere. So keep that in mind, and you'll I think it'll keep you balanced. One of the things that I urge students to do always when we're talking about the law is to think about how to measure the law. Some of you may have experience with the laws of other countries. Some of you may have very little experience at all with the law in the United States. But you all know somewhere deep in your heart that there's something or some things that we want out of the law. And what we want out of the law, I think, can be put into 4 or 5 categories. And when we put in those categories, what I say to you is measure our system throughout the semester on how well we do at these. So as an example, fairness. Is the legal system fair? If it's fair, it means it's doing what it set out to do. It means that it handles individuals not based on their on how much power they have or how much money they have, but based on what the rules we've created for society are. Is it fair? Do we get the right results? Are the right things being done? Fairness is obviously very squishy. It's a very subjective test, but nobody wants a legal system that is unfair. So as we go forward and we learn about torts and we learn about contracts and we learn about fraud and we learn about consent, ask yourself, are we getting it right? Is it fair? Ask yourself also, is the system flexible? One of the things we want is the ability to do things differently, different times for different people. Flexibility is inherently good, but it also is inherently at odds with a second measure that we look at, and that measure is predictability. One of the things we want is we want things that are predictable, but we also want things that are flexible. And every time it's more flexible, it's less predictable. Every time it's more predictable, it's less flexible. We want both. Can we have both? Yeah, we sometimes err by going too far to one and too far to the other. It's a balancing act. It's a tug of war that's always happening, and I love these tugs of war. So look at our system and ask yourself, is it fair? Is it predictable? Is it flexible? Also ask yourself, is it enforceable? Are we able to take what the judge says and make it happen? Are we able to take what the jury say and make it happen? I would suggest that a legal system that allows the courts to reach a decision but then doesn't have any ability to make it happen is a system that is inherently not very good. So as we go through and learn about the American legal system, ask yourself, how are we doing on fairness? How are we doing on predictability? How are we doing on flexibility? Okay? How are we doing on enforceability? I think these are all things that are important and things that we should consider. So know that the law is kind of organic. And when I say organic, what I mean is